Started now. So thank you guys for joining us. Today, we're going to talk about something that's near and dear to our hearts, love your legacy. We're going to help you secure your family's financial future. In this conversation, we're going to talk a little bit about how to align your financial plan with retirement and your legacy goals to make sure that your estate and assets are cared for after you pass. By the end of the session, I think you'll have some actionable steps to protect your loved ones and build a meaningful legacy. Before we get started, I want to introduce myself and our team. My name's Kelly Olczak. I am the managing partner of LynnLeigh Company. We're really happy to say that we're a 100% woman-owned registered investment advisor. And we're based out of the Bushnell's Basin in upstate New York, close to Rochester. We manage the finances for a handful of families in our community, and we are fiduciaries. What that means is we are committed to putting your best interest first, which is always good, I think. I am a certified financial planner, have been so since 2009, and I really enjoy helping people understand their financial goals and help them turn those goals into reality. Joining us today is Chaz Miller. She is our amazing operations manager. She's going to be playing the role of Vanna White today, moderating our session, keeping an eye out on the chat function so that if you have questions, she will tell me to stop talking because I love to talk. So don't feel like you can't chime in. Please do. We want this to be interactive. Additionally, we've got Becky Gillette, who is my partner. She and I started the firm a handful of years ago. She's our dedicated chief compliance officer. And what's important about that is very few firms of our size have somebody who's solely focused on compliance and operations. And we're super fortunate to have Becky helping us with that. What I'm going to do is we've only got one. Oops, I'm just going all over the place. We've only got one poll today to kind of center us to make sure that you guys are sharing with us what you're hoping to get out of this session. And it's very short and sweet. So Chaz, if you could do me a favor and launch that, we will. Oh, you did. There it is. Thank you. So if you guys could just take a couple minutes and help us with that, that'll give us some guidance. So we'll just take a couple more seconds here to get that poll finished, and then we will move forward. So thank you very much for helping us with this.
Al, I just shared that with you.
Great. Thank you very much. So understanding this is a very big topic, we are going to take it bite by bite, but I want to start with a story. And this is an actual story that we actually help folks with. But we're going to cover integrating your legacy planning into retirement and ensuring that you and your loved ones have checked all the boxes when it comes to estate planning. And then also, this is something that I've found that people don't always understand, all the bits and pieces around estate planning. So we're going to start with a real life story about a family that we work with. We're going to call them the Thompsons. Close-knit family. Sarah and Michael had 2 children, and they were young when, well, obviously they were young, but they were a young couple, and they always talked about creating a will, but kept putting it off. Nobody likes to talk about getting sick or dying, but they put it off when life got busy. They just kept assuming that they had time to planning. Unfortunately, Michael passed away unexpectedly, and with no will in place, Sarah found herself facing just an overwhelming amount of things that went into the legal process of Michael's estate. The assets that Michael assumed would go to his wife and children were instead tied up in probate, with courts deciding how to distribute them. And this is the biggest reason why we're doing this workshop right now. So many of our clients are in New York. So I'm going to talk to New York. But these are important things to cover if you're living in a different state. So in New York, when a person dies without a will, it's known as dying intestate. And in New York, intestate laws dictate that the state decides how the decedents, the person who died, how their assets are distributed. In this case, Sarah assumed she would inherit everything, but because they didn't have a will, she received the first $50,000 plus half of the remaining assets. The other half was allocated to their minor children and placed in a court-controlled account, making those funds unavailable to Sarah until the children reached the age of 18. And without a will, Sarah also couldn't be named as a custodian for those funds, which means she, even if they were the kids' inheritance, she could not manage them. So the state decided on who was the custodian. And that's pretty scary. So Sarah had to go through a formal legal process to become the administrator of the estate. And it was not automatic. She needed to petition what's called the surrogates court. And she had to provide lots of documentation. She had to post a bond, making the process both time-consuming and expensive, not to mention really stressful. Sorry, guys, I have an itchy eye. Because Michael didn't leave her clear instructions in a will, Sarah had limited authority to make decisions. And in situations involved, if there were family disputes, maybe Michael's parents or his side of the family, that can cause ripples. And no one likes to argue about money, but certainly not after somebody passes away. So this was especially difficult because the kids were minors. So I'm just going to take a step back. We do have clients that have young children, but we also have parents, people that are grandparents. So even if this doesn't relate to you directly, it is important for you to share with your kids so your grandkids don't fall into these types of traps. So when I say that Sarah couldn't access the dollars for her kids, their share of it was in a court-controlled account, meaning she couldn't get access to cover expenses, education, healthcare. It was an awful, awful long 2 years. And it did take 2 years. Sarah had to spend thousands of dollars in legal fees, tons of hours in the court, filing court hearings, managing probate. She was working with an attorney, but she was the person that was trying to get access to these funds. Disputes did arise with the extended family, who had different opinions on how certain assets should be handled. And what we've recognized is sometimes money make people do dumb things. And this is not the time when Sarah really needed to worry about that. She should have been focused on helping the kids, healing herself, and mending, okay? Sidebar. Let's say you don't have little kids, but you still die intestate. If you're unmarried, but you have a partner, your estate goes to your parents. If your parents are not alive, it goes to your siblings. And here's a shocker. If there are no surviving family, even if you have a partner, maybe you didn't get married, or maybe you decided not, getting married was tough. You didn't name your partner, you have no surviving family, the state will claim those assets, which I really hate. So just food for thought there. Okay. This whole situation is avoidable and could have been entirely avoidable if Sarah and Michael had taken the time to create a will, which sounds really simple, but people do not like to talk about this stuff. But if they had taken the time, Michael could have named Sarah as his executor or executrix. That's the female version of executor. And that would have given her immediate authority to manage the estate without court intervention. A will would have allowed him to specify how his assets should have been distributed, ensuring that Sarah had full access to the funds so she could take care of the family. They could have set up a trust for their children. Let's say Michael wanted to make sure that Sarah got a lot of the estate, but some of it went to the kids. They could have set up a trust that would have allowed the children to be named as beneficiaries, and that would have safeguarded their funds for the future. That would have saved so much stress. And while I'm doing this, if there's a topic, guys, if there's a topic you want to touch upon, please raise your hand, because I'd be willing to stop. There are not a ton of these slides, but I want to make sure that we have time to talk. Okay, so we're going to talk a little bit about protecting your estate. And I'm sure, like many people, you probably have someone in your past that has impacted you in a meaningful way. Maybe you inherited something, or maybe you've seen that sort of thing happen. That's what we're going to talk about. Legacy planning is more than just deciding who gets your money. We've got clients that, like I have one family who is very involved in rescuing dogs. And so they've carved out a portion of their estate to go to Lollipop Farm here in upstate New York to take care of animals. So it's really about how you can impact not just your family's well-being, but your passion projects. We've got another family that's very musical, and so they want to carve out some of their investments, not a ton, but some of their estate for Hochstein. Or the same family, the father is very into trains, and believe it or not, there is a nonprofit museum where he can leave some of his money to that group. So what we're going to talk about is how to combine your financial decisions, some legal tools, and your values to build that plan that helps you carry your legacy beyond your life. So if you know me, you know that I don't like anybody telling me what to do. You're not the boss of me is a favorite thing I say around here. This is really about controlling your legacy once you pass. Legacy, schmegacy. It means deciding how your assets get distributed, who will get them, those assets, when they get them, if you needed to do that, how other things in your estate, not just the money. The same family I was just talking about, dad had an heirloom given to him. His dad was an architect, and he had this gorgeous drafting table, antique, and he didn't want that to get sold. And so by doing all these things, you can reduce stress on your end, but also on your loved ones once you pass, but also reduce expenses with just a little bit of planning. And that's where Michael and Sarah got into trouble, because they didn't think that Michael was going to die at 52. They thought they had plenty of time, but the expenses were just so overwhelming. So these three topics: lack of preparedness, time and cost, family disputes. This is why this matters. So there's a survey by a company called caring.com, or a website called caring.com, that stated that 67% of Americans do not have a will. That blew my mind. And because of, so the why was important to me. Why? Well, procrastination is one thing, but also misunderstanding of the why it would matter is important. Without that, in New York, the average probate processing time takes 12 to 24 months, and it costs between 3 and 7% of the estate value in court and legal fees. And then this one was a really big bummer, and we've seen this. Studies show that 44% of Americans believe their families would have disagreements over financials if proper estate planning wasn't in place. And we have recognized that. The other thing I want to say is, obviously, we are not attorneys. We're not giving legal advice. We're sharing experiences with you guys to maybe help you dodge bullets or shorten your learning curve. So in the end of this presentation, I'll share with you some ideas on how to get help. So legacy planning starts with knowing what you have to work with, meaning your home, maybe some properties, maybe you have a business, your pensions, investable assets. A lot of people think that this is all about money, but it's about tangible items. It might be the heirloom, okay? But if you have an idea of what those assets are, what your stuff is, it'll help you to start to define what your legacy goals are. And this ensures that your day-to-day retirement needs are met, because when you save for retirement, that money belongs to you, but you may want different things to go to different people once you pass. So now we're going to talk a little bit about how to protect your family and the future. So I am a certified financial planner, and I always start with the question, well, what's the money supposed to do? I'm a planner. And now that we've had a little bit of conversation around planning, let's see how this could have changed Michael and Sarah's story. Let's talk about actionable steps that you can take to align your legacy goals with retirement planning. So when we talk about the dollar amounts, pensions, investments, Social Security, it helps to start with making sure you have enough money through your retirement. I've had families who've said, well, we want to make sure that the kids have something. And my first comment is, I cannot get you a loan for retirement. We got to make sure that the dollars and investments that you have will help you have a great retirement. It's what happens after that matters. So I like to say there's three kinds of money, okay? There's now money, later money, and never money. So now money is like your savings, your checking. Maybe in savings you have 3 to 6 months in what I call uh-oh money. Uh-oh, the hot water heater went. The later money is your retirement savings, your non-IRA money, your 401k, your Roth, your IRA. The legacy is all about the later money, but we don't want you to worry about having a great retirement. We want to work on retirement first, but legacy keeps coming up for lots of our conversations. So here we are. So when we are talking about different ways to make sure that your investments or your assets, your stuff flows, there are different kinds of strategies you could use. And we're going to talk about the dollar stuff now, but it does include trusts. So when we discuss tax efficient strategies to preserve your wealth and simplify your transfer of assets for your loved ones, what we're hoping to do with these next couple slides is to help you understand the ways that you can minimize taxes, avoid probate, and my allergies are killing me, sorry, and ensure your financial legacy is aligning with your goals. So first, we're going to talk about trust, but there's two kind of ways you can move money after you pass: wills and trusts. So we're going to talk about different kinds of trusts right now. Trusts are powerful tools for both dollars and cents, meaning investable assets, and stuff, property, the drafting table that my client had. And a trust will allow you to control where those dollars go after you pass away. They are powerful tools for both asset protection and avoiding probate. A revocable trust allows you to maintain control of your assets during your lifetime while ensuring a smooth transitions to your heirs after you pass. A revocable trust means that those assets belong to you. When we switch gears to irrevocable trusts, you lose control over those assets, but they do shield those assets from estate taxes and provide guidance on where you want those dollars to go after you die. So I like to say that irrevocable trusts help you manage where you want your assets to go from your grave. Are there any questions yet? Okay. The next thing you can do, again, this is going back to tax efficient strategies for your heirs. You may consider, if you don't have a Roth, maybe Roth conversions. And by converting some of your IRA dollars to a Roth IRA, you pay taxes up front, which means when your heirs inherit the Roth, they do not have any taxes on the distribution of Roths when they inherit them. That being said, Roth conversions are very ticklish for every single person. Every person is different. We're just sharing ideas on ways to help you move assets, investable assets, to your loved ones in a tax efficient manner. And that's why I asked if anybody had a hand raised, because some of this stuff is a little technical, but it doesn't mean I can't talk to you guys afterwards if you want to talk later. Okay. The biggest thing that I honk at with our clients is making sure we keep our beneficiaries updated. So what we're going to talk about right now are how to add beneficiaries to different kinds of accounts that are not IRAs or 401ks or any other retirement account. So if you have an IRA or a 401k, you have put beneficiaries on those accounts, okay? And that means maybe, like for my husband and I, Gene has me as his primary beneficiary, and then the kids are second, and vice versa. I have Gene primary, and then the kids are second for me. When you talk about non-IRAs, we're going to say brokerage accounts. These are non-IRA investment accounts. They have something called a transfer on death. And a transfer on death is just like the beneficiaries for your IRA or 401k. My husband would be my primary beneficiary for my brokerage account, and the kids would be second. Okay. If you have a bank account, it's called payable on death. Same thing, just banks call it different. Okay. By naming beneficiaries directly on your account, that means those investments, those assets, whether it's a savings account, a checking account, a brokerage account, They will not go through probate. So your beneficiaries will have access to those accounts much sooner than if they had to go through probate. Now, big sidebar. We again are not giving legal advice, but it's important to communicate with your trust and estate attorney when you set up these strategies. Because if you have created a trust in your will, these type of designations will bypass that work that's in your will. So I'm just giving you ideas. A transfer on death and a payable on death are called will substitutes, which means they supersede any language in your trust and estate paperwork. If you don't align that with your attorney, that might mess things up. So I'm just being very careful with you on that. Okay. So then we've got annual gift exclusions. So this is a way that you can give dollars throughout your life to your beneficiaries without a taxable event. So this year, each individual person can gift anybody they want $18,000 without having a taxable event, meaning having to fill out a tax form for your next tax year. Okay. So if you're married, you both can give $18,000 to your kid or anybody you want. So that's another efficient way to move assets out of your estate. So flexibility is one of the most important aspects of successful legacy and retirement planning, because, life changes. You never know what's coming. And what we see is that people forget to keep an eye on things. So periodic review of your plans is very important. So we like to say, check in with your trust and estate attorney and just update if anything's have changed. Or if a major life event has occurred, like a marriage or a birth or a divorce or a significant financial change. These reviews ensure your plans remain aligned with your goals, no matter how your circumstances evolve. So adjusting contributions as needed. So we have some folks that have set up monthly contributions to their kids or their grandkids, okay? And it's automatic and they just set it up and then they forget they've done it and then something unexpected happens. So it's really important to just keep an eye on, if something big happens, something changes, remember that maybe you've got things set up automatically, maybe in your bank or with your advisor. So these tools like revocable trusts and Roth IRAs, they provide flexibility that can be adjusted over time. Okay, so for instance, a revocable trust can be modified to reflect evolving family dynamics. So as an example, we've got a family who has 3 kids. One of them went through uh, uh, a bankruptcy, and the way mom and dad had their estate paperwork set up is that all 3 kids would get equal amounts. When this kid had this trouble, which was not her fault, by the way, mom and dad changed it to a certain kind of trust that would protect her inheritance from creditors. So that's what I mean about adaptive tools. Um, it's really about staying on top of things, staying proactive to make sure that your financial plan can weather any changes that come on. So this was one that really keeps me up awake at night, because 77%, sorry, I forgot the percentage there, Americans experience a significant life change like marriage, divorce, or having kids that require an update to their beneficiaries or their estate planning. We had a family who, blended family, mom and dad divorced, dad got remarried, and he forgot to update his life insurance and his pension to his not ex-wife, his current wife. And once he passed away, there was nothing they could do about that. So these are the little things that keep Kelly awake at night. So here's some ideas. So let's step back a bit. People hate to talk about money. People hate to talk about when they die. But these are the things we're going to share with you that we have found so important about once you've figured out what your trust and estate wants to look like, how you communicate to your family. So here's some things that you can help build a strong safety net for your family. Life insurance is certainly one of the most effective ways to ensure your financial security and your family's. I like to say, we've had folks come in and they're in their 50s, like, we bought this policy when we got married, and it's a cash policy, and I don't think we need it anymore. Well, the reason why you own that policy, the reason why you bought that policy is different than why you might want to keep it now. So they bought the initial life insurance policies on each other. So if one of them passed away, the house was paid for, kids could go to college, and they replaced some income. Now, fast forward, they're about to retire, and they may want to make a couple changes to it, but it's still intact. And it just because you don't, quote, need it anymore doesn't mean you don't want it. Okay. So it may be able to help extend your legacy. For those of you who have worked with us in the past, I love the uh-oh account. Emergency funds are so, so important. And like I said, there are three different kinds of money: the now money, the later money, the never money. Emergency funds savings are now money. So they're going to help you with unexpected, oh my gosh, the hot water heater went, or an unexpected medical bill. So I really do like to see that people have an emergency cushion about 3 to 6 months. Health insurance and long-term care planning are really important, obviously. Understanding your health insurance after you retire is really important. Understanding your Medicare options is really important. Understanding your health insurance if you get laid off before you're eligible for Medicare is really important. And then having a strong understanding of what your long-term care issues might be once you, like, if, God forbid, you need long-term care. So here's the part about the conversation. And this is something that makes people cringe sometimes, but I have found that one of the most important but overlooked aspects of financial planning and legacy planning is talking about it. It's not just about creating a plan, it's making sure your kids or your loved ones or whoever your beneficiaries are understand what you want if you can't tell them. So we really encourage families to talk about this sort of thing. It is hard. So what I like to do is ask my clients to write a letter. So maybe you don't want to talk about it, but writing a letter in your own handwriting can really effectively communicate what's critical. So this has helped us with our clients when they've got kids. Maybe two of them get along, one doesn't, and the oldest is responsible as the executor or executrix. That handwritten letter does help folks understand this is what mom and dad wanted. It needs to talk about your financial goals, what your passions are, what your values are. My grandfather almost had to make a decision to put money into a creditor trust. And so I had him write a letter. Turned out that everything worked out, but that was the biggest thing he was worried about at age 93. So he was able to document what his special instructions were and the why. Okay, it does prevent conflict, or at least it tries to. Like I said earlier, money makes people do stupid things, especially if there's disagreements in the family. You just want to really try, if you can, to help your loved ones understand what you want. So these family meetings and family letters are really helpful. It does create a legacy of transparency, and it does start a conversation. My father literally, not this past Christmas, but 2 Christmases ago, mentioned that when he passes away, so I'm the executrix, when he passes away, he wants some of his ashes to be spread into a little fly brook that we have up in the Adirondacks, which was very surprising. He dropped that in my lap. 2 days later, my brother walked in, and I said that I explained that to him, and my brother was totally cool with it. But now I know where he wants to go, because my dad doesn't like to talk about these things. Really, it's all about making sure that when the communication occurs, the person, like me, I am the executrix, has an opportunity to talk to my siblings to say, these are the things that are important to my mom and dad. And when I have to, unfortunately, make decisions, it's not a surprise to my brothers. Okay, so let's revisit Michael and Sarah. Any questions before I move forward? I know I'm rolling here. Okay, thanks,
No.
Chad. So let's revisit Michael and Sarah's situation, understand how a will and trust could have made a big difference. So as we saw, Michael passed away without a will and left Sarah with a ton of burden. In this situation, a will, which is a legal document, would have specified how Michael's assets would be distributed after he died. Same with Sarah. So Sarah would have had a will, Michael would have had a will. They're individual documents, but they talk about what each person wants once they pass. And it does require probate. It's important to know that probate doesn't always take years. If you do the paperwork right, it can go pretty quickly. But when you have a will, the will needs to be validated through probate, where the court oversees the distribution of assets. So the executor or executrix, like I will be monitored. My activities will be monitored by the court to make sure that I'm following what the will says I need to do. And typically, it takes a couple months. It can be delayed by disputes, or if the will isn't clear. And you can't always protect all of that or control all of that. And we'll talk more about that in a second. Legal costs for probate. So probate usually involves legal fees and court costs that will reduce the value of the estate. So it's costs are based on a percentage of the estate. In Michael's case, if he had a will, obviously we talked about this, Sarah would have been able to get at those assets pretty quickly. By contrast, a trust avoids probate, making it faster and more private. That's important also. So a will is a simple outline of who gets what after you die, but it does not provide flexibility or control once the person passes away. Michael's will would have only specified who inherited what, but Sarah would still have had to wait for court's approval to access the assets. A trust, on the other hand, would allow more control over how the assets were distributed. In this example, Michael could have set conditions on when Sarah or the children could have access to certain assets. And that could have been helpful in getting assets right to Sarah directly. So my husband and I have a joint account, joint savings account, joint checking account, but I have my own checking account. But my husband is the payable on death. So he's a beneficiary of such. So in that case, that's not a trust, but in that case, my husband would be able to get at those assets quickly without those assets going through probate. A will is public. Whatever goes through probate, it will be documented and it's public record. Whereas a trust is private and it will not go through probate. It does not require public filing. A will is a one-time distribution document. So it's a legal document that tells the courts where you want your assets to go. It can be updated during your lifetime, but once that person passes, it's not flexible anymore. So I've had folks that have kind of been stuck getting their wills done because, like my mom and dad as an example. My mom and dad have lots of really nice paintings. They're not wicked expensive, but they mean something to them. And they wanted to make sure that those paintings went to the art museum in their town. So they had their attorney craft that so it went right to, like, it was a carve out just for those paintings. Okay. That is not in a trust. So they could change who gets those paintings, but once they pass, I'm going to have to make sure that the gallery gets that. Whereas a trust does allow for ongoing management, even even after you pass. Okay, so a revocable trust allows the creator, my dad as an example, who's called the grantor, to modify it and change it until he passes. And then after the grantor's death, the executrix, in my case, would be responsible for following the letter of law, but that doesn't go through probate. So it's a little bit more flexible. Okay, so we're in the home stretch here. So properly naming primary and contingent beneficiaries is crucial. Michael and Sarah's situation is super big highlight to that. And if they had done that, the beneficiaries, that would have really helped change how soon Sarah could have gotten those assets. So typically, not always, but when we do see beneficiary designation, let's say we've got a husband and wife and they both have retirement accounts with us. Michael would have Sarah as his primary beneficiary and the kids as contingent beneficiaries. Now, their children were minors. So the contingent beneficiary would be called out to refer to their will. Let me just say that again. Michael and Sarah's children would not be contingent beneficiaries on their IRAs because that would have gone through probate. That's a big pain. So they would have added the contingent to refer to their trust and estate documents. Same naming trusts as beneficiaries. That's the part I was just talking about. They had a trust set up for the children because they were minors. And the trust basically said, this is a trust that goes until the kids are age of majority. So in New York, that's 21. Other states are different. Some are 18. But if they had just named a trust for the children, where Sarah was the trustee of the trust, she could have managed the kids' inheritance without having to worry about the state deciding. Regular review. This is my squeaky wheel. I like to see folks update their beneficiaries, or at least know what their beneficiaries are, very frequently. So when we do our annual reviews with our clients, we review the accounts that we are responsible for, but we also have a little checklist on when was the last time you looked at your beneficiaries for your 401k or for your life insurance. Sometimes when a 401k gets moved from one vendor to another, those beneficiary designations may not follow. And we don't manage those. So that's just sort of my squeaky wheel. So again, squeaky wheel. Naming minors as beneficiaries, naming an ex-spouse. These are things that we've seen in the past that really, if they don't change, you can't, like, if you don't change them on a life insurance policy or your 401k and you pass away, that's it. Whoever's on that document gets the assets. Okay. So I really hope that this is not overwhelming. I hope this is giving some clarity, but it really is vital that the process goes on. If your life changes, so should your plan. There's my squeaky wheel. Update, update, update. So estate laws, tax laws, and regulations are not static. We've had some clients who've said, oh, I got my will done. Well, when did you do that? 2003. There have been a lot of changes, trust and estate changes, tax-wise, law-wise, that have changed. Getting your will updated should not be expensive unless you've got lots of properties or lots of businesses. But so a lot of people have also said, well, I don't want to spend the money. You want to spend the money, let me tell you. But making sure that you adapt your trust and estate documents to align with changes in federal exemptions thresholds, estate taxes, are really important. And please, please do not use LegalZoom. I do have a lot of engineers who are very fee sensitive and very smart. And I will say to them, I don't care how smart you are, you do not do this on your own. This is bad. So working with trust and estate attorney in your state is crucial because each state's circumstances are unique. So Sally, I know that you just moved down to North Carolina, and just having somebody look at your existing will doesn't mean it needs to be rewritten, but just having somebody in your state look at your will to make sure that whatever was written in New York flows through to North Carolina. That would be great. And I know it's tempting to try and do it on your own, but please, please, baby Jesus, don't do it. Okay, so at the end of this workshop, you're going to get some helpful handouts. And these checklists are really helpful because they're going to say things that you might want to think about when you're considering your estate plan, when you're defining who your beneficiaries are, when what documents you need to gather. So you'll be able to access these when we're done here. And I did it in under an hour. That's awesome. So that is all I have right now. Retirement and legacy planning are not just the end of the career or wherever you work through to get to retirement. It's literally the next chapter of your life, and we want it to be really happy. So hopefully this presentation has given you some things to think about. And I would love to hear any feedback you have. There's a survey you will have at the end. I'd be grateful for any feedback. We want to know what we did well, what we could do better, maybe what you'd like to hear about. Are there any questions about today's presentation or any comments? And who said I can't talk straight for an hour?
There's none in the chat, Cal, but
Thanks,
folks
chat.
can feel free to reach out if this drums up any questions.
Great. Well, thank you, everybody. I hope you have a great weekend. And as always, we're here if you need us, and hope to hear from you soon. Thank you.